Social media laws in India by Swathi J. Gupta, legal intern into legal world. Introduction. What is social media? The term social in regards to media suggests that platforms are user oriented and becomes a place for communal activity. It becomes technology, communications, and social interactions and offers a platform to exchange ideas through written words, images, moving visuals, and musical compositions. Different options of social media. There are different types of social media, such as social networking sites like Facebook, Instagram, Twitter, Gmail, Telegram, and many more. Blogs, vlogs, social news, etc. All these options are just to make accessible to people accordingly. Law relating to social media. There are three categories. Number one, the Information Technology Act, Constitution of India, and Indian Penal Code. Under the Information Technology Act, we come across Section 66, Clause A. According to this section, if any person who sends a message by any means of communication device in any information that is offensive and if specially created to annoy, spread, spread hatred, criminal intimidation shall be punished with imprisonment which may extend to a term of 3 years and fine. And one more section under this, section 69 clause A. This section says that the government has the right to ban or stop public access to information that is not consistent with provisions of the government, and this section also provides a procedure of blocking access of the public to certain informations. Who doesn't apply with this provision will be punished with imprisonment for a term which may extend to 7 years and shall also be liable to pay the fine. And second one is Constitution of India. The Constitution of India provides certain basic rights of citizens to India. These rights protects their basic life interest, and if it is violated, remedy is provided to them. Under Article 19 of the Indian Constitution talks about right to freedom. There is no specific mention of freedom of press or media, but it flows through Article 19 Clause A, which is the right to freedom of speech and expression. Dr. Ambedkar quoted, "Freedom of press is essential for political liberty." I will repeat it again. Dr. Ambedkar quoted, "Freedom of press is essential for political liberty." When men cannot freely convey their thoughts is to one another, no freedom is secured. Where freedom of expression exists, the beginning of free society and means of every retention of liberty are already present. Free expression is therefore unique among liberties. There is no specific clause for freedom of the press, but liberty of the press is included in the freedom of speech and expression. The press has no special rights or liberty as an entity, but it has the same liberty and right as provided to individuals of the country under freedom of speech and expression. For example, we can say journalists, editors can claim freedom of speech and expression as any other citizen claims it under Article 19 Clause A. The Indian Press Commission has rightly opined that the democracy of a country cannot be protected only through the help of legislature, but the opinion of people also matters, and what better medium other than media or press. Under Indian Penal Code, I will discuss about it now. The official criminal code of India is known as the Penal Indian Penal Code (IPC). It is a true it is a thorough code that aims to cover all important areas of criminal law. Any person who violated the laws mentioned above will be dealt with under provisions of IPC. Here I will speak about section 295A of IPC, defaming religion or religious beliefs on purpose. Section 153A, encouraging hostility between groups based on race, religion, etc. Under Section 499, deals with defamation. According to this, anybody who makes a defamatory comment in writing or verbally with the goal to destroy someone's reputation faces legal consequences. Section 499 and 500 of the law are the primary safeguards against social media abuse. Under Section 505, it deals with statements that incite public annoyance. Section 509, disrespecting women's modesty. Section 124A deals with sedition, which means that a criminal act that encourages opposition that has potential to bring down the government. There is a landmark judgment under this concept, Shreya Singhal versus Union of India. Case explanation. In this case, Section 66 Clause A and 69 Clause A of the Information Technology Act were challenging starting, that is violating Article 19 Clause 1 Subclause A and Article 14 of the Indian Constitution. The court stated that there is no intelligent differentia, that is difference capable of being understood. There is no difference between the other mediums and the internet to carry out any information. The Supreme Court opined in this landmark judgment that is Section 66 Clause A of the IT Act should be struck down as it is violated freedom of speech and expressions under 19 clause 1 and subclause A of the constitution, and it was not saved by under any article 19 clause 2 which imposes reasonable restriction. Supreme Court says that section 66 clause A is open ended, undefined, and constitutionally vague with the words used in the statute. This section invades the right to free speech, the right to dissent, the right to know. Further, court added that this statute that no proximity relationship to public order failed to pass clear and pass danger test, that is US doctrine, which questions in case whether the words used are dangerous and will create havoc that government has a right to prevent. It is a question of proximity of degree. Conclusion. Because we live in a technologically advanced age, social media use has dramatically increased. According to a study, consumers spend 142 minutes a day on social media an average. With the rise of social media, it is essential to establish specialized legislative framework to control it. It protects users from abuse and prevent cyberbullying. Finally, we might add that social media is both blessing and a curse. Thank you.